Since seeing our coverage of Mac Lorenz's case back in February, attorney Michael Comorn from the east side of the state took on Max's case pro bono. And Comorn tells me for the last 6 years, he's dedicated his practice exclusively to the medical marijuana patient and caregiver representation. Comorn calls Max's case scandalous and says a major problem here is that law enforcement are dealing with more of a public health issue. Like many card-carrying medical marijuana patients across the state, Max Lorenz finds himself caught between his doctor's orders and a judge.
When I followed my doctor's recommendations, that's when my health started to get better. Going back and following what the judge is saying, my health's been just deteriorating ever since. And so it's a scary road I'm going down, but I have to comply with what they're asking, and I just don't know what else to do.
But his case has come with some devastating consequences. In February, Max was charged with a 2-year felony, possession of a Schedule I controlled synthetic substance. Now his 5-year-old son has been taken away, leaving him with just supervised visits. And all of this because Max called 911 in September for a family medical emergency, when the deputy who responded to the call found a smear of butane hash oil in his home. It's a substance Max ingests for what he calls deep pain relief, something he obtains with his medical marijuana card.
I'm outraged by it. It shouldn't have happened.
Max's attorney, Michael Comorn, specializes in these cases. He says medical marijuana is not a controlled substance. In fact, Michigan law states marijuana is a Schedule II drug. But because Max is charged with having a Schedule I drug and not specifically marijuana, Comorn says it's difficult now to protect Max under Section 8 immunity of the Michigan Medical Marijuana Act.
Schedule I, by definition, means what?
Is a controlled substance that has no quote-unquote medical use.
Comorn believes part of the issue here is a recent policy change in Michigan State Police lab reporting.
They had a policy change, but why? The policy change, the motivation for it was that if they report it this way, people like Max won't be able to claim a medical marijuana defense.
The lab tech in Max's case testified that he's been testing tetrahydrocannabinol, or THC, for 23 years. THC is the main psychoactive ingredient in marijuana, and it's also present in synthetics. But a recent policy change means he has to write origin unknown when testing this type of THC on lab reports. The tech says he can't tell if it's synthetic or if it's natural.
In this particular case, a quantitation was not done, and therefore I could not conclude whether or not it was hemp. You're correct.
Take a look at the lab report for the residue Max had in his home. The tech named it to be THC, but then wrote origin unknown, labeling it a Schedule I drug. Now compare this with similar lab reports from 2012, before the policy change, where THC is only stated, suggesting it comes from a marijuana plant. The prosecution argues Max's residue was not marijuana.
This is not usable marijuana as described in the Carruthers case. Does not describe it as a plant at all or any plant material. We would ask the court to bind it over as charged.
Comorn says this policy change is the difference between a felony and no charge at all for Max, saying he should be protected under the Michigan Medical Marijuana Act. He asked the judge to dismiss it.
They admitted that on the stand. That is very, very, very disturbing to me, because it means that the politics and law are affecting the truth. That's not how it's supposed. We're supposed to rely on science to make the case.
But for now, Max says he's following court's orders and he's back to taking what he calls debilitating prescription pain pills. But he's fighting to get his son back and then to use the medicine that he says works best without having to smoke it.
If nobody stands up for this and it just keeps going the way it is, how many more people are going to get thrown under the bus just for using their prescribed medicine? And it's just ridiculous.
And another point in Max's case is that the prosecution is arguing that Max's hash oil is not, quote, usable marijuana, something that's defined in a previous case called People versus Carruthers. Now, usable marijuana there is just from the plant material, but Comorn argues that a hash extraction comes directly from the resin of the marijuana plant, which he says would be legal. Now, we'll stay on top of this case and let you know the outcome. Meantime, there is pending legislation that would rewrite the medical marijuana laws, and they've been reintroduced in Lansing. In the studio, Dana Chiklis, Fox 17 News.